CPLR Quiz 6. 1. A post-trial motion must be made within 15 days after a verdict, decision, or discharge of jury. So post-trial motion equals 15 days. 2. At any time during trial, the court on motion of any party can order a new trial, a continuance in the interest of justice, or on just terms. 3. A motion seeking to have a court confirm or reject the verdict of an advisory jury or the report of a referee shall be made within 15 days after a verdict, report, and prior to further trial. So post-trial motion, confirm or reject advisory jury or referee report, 15 days. Okay, and it's a referee to report there. 4. If a plaintiff obtains a money judgment which includes interest, it's computed by the clerk. 5. What's exempt from satisfaction of a money judgment? Now, all stoves, one TV, a watch worth $45 is okay because it's watch, jewelry, or art, and it's got to be under $1,000. Family Bible, always exempt. An engagement ring with no price on it is no good. So the answer was A, 1, 2, 3, and 5, but not the engagement ring, because what if the engagement ring is Jennifer Lopez's engagement ring, which is like $3 million? That's not exempt. All right, here we go with true or false. Now, almost a lot of these are going to be false. So 6 is false. Any non-party may serve a summons. No, they got to be 18 or over. 7, false. A court may relieve a party from adverse judgment on grounds of excusable default at any time. False. It's got to be within 1 year for excusable default, 1 year. 8, false. Application for default judgments must be made to the clerk or the court. 9, false. A motion for summary judgment not be made at the commencement of any action. It can't be made in a matrimonial, and you can't necessarily make it in the beginning. You have to wait for them to answer. 10 is false. The judgment roll can be prepared by the clerk as well as the prevailing party or their attorney. 11, plaintiff and defendant may stipulate to submit a case to the court under New York Simplified Procedure. That is true. 12 is true. A motion for summary judgment must be denied if there's any triable issue of fact. That's true. The essence of a motion for summary judgment is that there's no triable issues of fact. 13, this is false. A satisfaction piece or a partial satisfaction piece is official evidence that a debt has been satisfied. 14 is false. The amount is wrong. Those are crazy amounts. I'll send you the video with that, or I'll add it to the civil playlist. And it can't be any real property. It has to be a homestead or a burying ground. 14A, this is false. Every order directing the payment of money which has been docketed as a judgment shall bear interest from the date of such docketing. Okay? So a regular money judgment bears interest from the date of its entry. But an order directing payment of money that's docketed as a judgment, that bears interest from the date of such docketing. That was a question on one of the tests in 2013. 15, the date from which interest is to be computed shall be specified in the verdict, report, or decision. 16, the rate of interest shall be 9% per annum. Oh God, I hope they give you that question, 9%. 17, the determination of the rights of the parties in an action or special proceeding is a judgment. What's a judgment? It's the determination of the rights of the parties to an action or a special proceeding. 18, the court which rendered a judgment or order may relieve a party on ground of excusable default if they make the motion within 1 year after service of the order and written notice of entry. 19, in order to enter a judgment, the clerk must sign the judgment and file the judgment. So sign and file. 20, 50, 17. This is a list here. You have to know about a judgment roll. It's SPAJO, S-P-A-J-O, stands for summons, pleadings, admissions, judgment, and orders affecting the judgment. And these are all true. It's a study question for you. 1 may be prepared by the prevailing party's attorney. True. 2 may be prepared by the clerk. Also true. 3 must contain the pleadings. That's true because it says SPAJO and P stands for pleadings. 4, if appeal was taken, it must contain determination and opinion of each appellate court. That's also true. 5, if a trial was had, it shall contain the verdict or decision. 21, except for income executions for spousal child support in general, 90% of the debtor's income is exempt from levy to pay a judgment. So if Capital One gets a judgment against you, they can only take 10% of your salary. 22, for the purpose of a support order, a default is defined as the failure to remit 3 payments. Now remember, 3 payments for a default, and for the license suspension, you have to miss 4 months worth of payments. 23, mistake of fact equals 15 and 45. All right, when an execution has been issued by a support collection unit, debtor may assert a mistake of fact and opportunity to make a submission in support of the objection within 15 days from service. Thereafter, the agency shall determine the merits and notify the debtor of its determination within 45 days after notice to the debtor. So mistake of fact is 15 and 45, and obviously the debtor is going to get the smaller amount of time. The agency is always going to get more. 24, in general, if a debtor is supporting a spouse or dependent child other than the creditor in whose favor a support has been issued, so he's got 2 baby mamas, the deductions cannot exceed 50% of their earnings unless there's arrears, and it can be up to 55%. If they only got 1 baby mama, then it's 60 and 65% with arrears. But for 2 baby mamas or more, it's 50, 55. 25, not more than 60 days after issue is joined, the plaintiff in a med mal, dental, or podiatric action shall file with the clerk in which the action is commenced a notice of med mal. So it's actually called a notice of dental, medical, or podiatric malpractice action, but I just abbreviate it as notice of med mal. And there is a typo there. It should say notice of. 26, if a party who is terminally ill files a request for expedited preliminary conference, the court shall hold such conference within 20 days of the filing of the request. So if you don't remember that one, just guess 20 days. 27, a party served with a note of issue not containing a jury demand may make a jury demand by serving all other parties and filing a jury demand within 15 days after service of the note of issue. Okay, so we got a lot of 15-day rules in here so far. We got the mistake of fact, it was 15 and 45. The jury demand for the other party is 15 days. Post-trial motion made within 15 days. Confirm or reject a referee report. Verdict of advisory jury is 15 days. So also note that a party cannot withdraw the request for jury demand without consent of other parties in regular civil. It's different in surrogates. 28, a party may file a note of issue at any time after issue is first joined or 40 days after service of a summons has been completed, irrespective of joinder of issue. So the answer is C, 1 and 4, but not 2 and 3. You're like, where the fuck did they get 40 days from? I'm going to tell you where they got it from. Actually, no, I'm not. You don't need to know that. Just know it's 40 days after service of the summons has been completed, irrespective of joinder of issue, or at any time after issue is first joined, you can file a note of issue. 29, in general, the Court of Appeals reviews questions of law only. The only time the Court of Appeals in New York would review questions of fact would be if the appellate division found different facts. 30, if an attorney for an aggrieved party dies or whatever, the time for taking an appeal or moving for permission to appeal without having done so, such appeal may be served within 60 days from the date of the death or commencement of incapacity or disability. So I have a math problem here for you. It says attorney dies plus appeal equals add 60 days from date of death. 31, if a losing party decides to take an appeal, they must file the notice of appeal in the court of original instance in the office where the judgment or order of the court of original instance is entered. And to take an appeal, you serve your notice of appeal and you file the notice of appeal. You have to do both. 32, I know you know this one. Motion to appeal, motion for leave to appeal, 30 days. Must be noticed to be heard at least 8, not more than 15 days after the motion is served. And number 33, cross appeal is 10 days. So that time rule is 38, 15, 10. Another 15-day rule, wow. So number 33, just to reiterate, in general, if a party is served with a notice of appeal, he or she must serve the notice of cross appeal within 10 days. And on the 2012 Associate Principal, they asked a crazy question about the statement in lieu of record on appeal or something like that, and the answer was 20 days. 34, whenever an appeal is taken to the Court of Appeals, a copy of the notice of appeal shall be sent forthwith to the clerk of the Court of Appeals by the clerk of the office where the notice of appeal is required to be filed. So most likely that would be the appellate division. 35. The appellate division only may grant, modify, or limit a preliminary injunction or a TRO pending an appeal or determination of a motion for permission to appeal in any case specified in 6301. Now, Article 63 isn't on your test, but Article 55 is. So just know that preliminary injunction, temporary restraining order, pending an appeal can only be granted, modified, or limited by the appellate division. Now we get to skip all the way to number 42. We have, pursuant to 5205, certain payments payable to members of the U.S. Armed Forces are exempt from application to satisfaction of unpaid judgments. Protected persons include privates, non-commissioned officers, and musicians only. No commissioned officers. And that does not apply if it's a support order. Okay? Does apply if the money is owed to the government, but it does not apply if it's a support order. 43. This is a repeat question. The answer, yes, it's true. At any time during the trial, they can order a continuance. Basically, they can order a continuance is like an adjournment. 44. Upon being served with an information subpoena, the person must answer in writing under oath. Answers have to be returned within 7 days after receipt. So information subpoena equals 7 days. 45. The clerk may vacate a default judgment by the filing with him or her of a stipulation of consent to such vacatur by the parties personally or by their attorneys. And that is true. It doesn't have to be by the lawyers. It can be by the parties personally. 46. Here is a study question. Oh, it's a long read. The court which rendered a judgment or order may relieve a party on the following grounds. 1. Excusable defaults within 1 year of such notice of entry. The first one has to be within 1 year, but the rest of these could be whenever. And it's newly discovered evidence, which would probably have produced a different result at the trial, and they could not have discovered it in time to move for a new trial under 4404. Or 3. Fraud, misrepresentation, or misconduct of an adverse party. Or 4. Lack of jurisdiction to render the judgment or order. And when they say that, they're talking about subject matter jurisdiction there. Or 5. Reversal, modification, or vacatur of a prior judgment or order upon which it is based. So the answer was all of those, all of the above. Now, number 47. So this question, this was actually okay, so I'll just tell you a quick story about this question. Please read it. My grandfather actually used to be a court attorney, or back then they called it a law secretary, for Judge Thompson, who was an administrative judge. And they used to just, these plaintiffs, attorneys for debt collectors, used to just not serve stuff. They would claim they served things on people that were dead. It was completely ridiculous. There was millions of erroneously taken default judgments. So he basically didn't even know if he was allowed to do this. He put them all on a docket and dismissed them all and got rid of them. The legislature was like, yeah, you know what? This had to be done, and we're going to give the administrative judge authority to do it. So that is why 15 sub C was passed. An administrative judge, upon showing that default judgments were obtained by fraud, misrepresentation, illegality, unconscionability, lack of due service, violation of law, other illegalities, or where such default judgments were obtained in cases where those defendants would be uniformly entitled to interpose a defense, including but not limited to the foregoing defenses that I just read, and they were obtained in a number deemed by such administrative judge to justify an action set forth herein, upon appropriate notice to counsel for the parties, may bring a proceeding to relieve them from the judgments. This disposition of any proceeding shall be determined by a judge other than the administrative judge. And the administrative judge is actually the one bringing the proceeding. And it's all of the above. This is a great question. I don't know if they'll ask it, but it would be a good question to know, because you should know that an administrative judge has that power. 48. A restraining order may not be served on who? The answer is a judgment debtor's employer, where the property sought to be restrained, where the property sought, that's a typo there, should say property sought to be restrained, consists of wages or salary due or to become due to the debtor or obligor. So the answer is 4 only, because we do not serve a restraining order on employers. We serve income executions or income deduction orders on employers. 5222, a judgment debtor, obligor, served with restraining notice, is forbidden to make a sale, assignment, transfer the property in which they have an interest, except upon direction of the sheriff or pursuant to court order. So we obviously know a court order, yes, they can do it, but it's the sheriff can direct them to do it. 50, true or false? Leave of court is required to serve more than one restraining notice upon the same person with respect to a judgment or order, and that is true. Please make sure you study the appeal preferences reflected in Family Court Act 3710-10A, Parts 1 and 2 of Article 6, 358A, 383C, and 384B of the Social Services Law, especially the rule that a motion for a preference is not required. It's an automatic preference for juvenile delinquents, person in need of supervision, neglect, all that shit in family court. That's an automatic preference. Otherwise, you gotta make a motion for a preference. C1, a motion for judgment during trial does not waive the right to a trial by jury, even if it is made by all parties, and that sounds ridiculous, but it's true. 52. The answer here is 1 and 3, but not 2. So the reason it's wrong is because just because someone is an inmate, it does not automatically mean that they were granted poor person status. So if they were granted poor person status, then yes, the money is paid into the court. Still not to the clerk of the county, but it's paid to into the court. But if the person was just an inmate and for some reason they didn't apply and grant poor person status to that person, then the only rules is you got to wait 30 days before they get paid, and the court shall promptly notify the Office of Victim Services. Number 1, the court shall give prompt written notice to the Office of Victim Services, and the court shall direct that no payment be made to such inmate or prisoner for a period of 30 days following the entry of an order containing such direction. And this is talking about when damages are awarded to an inmate, what happens to the money. 53, in general, a motor vehicle not exceeding $4,000 in value above liens and encumbrances, and $10,000 if it's a disabled van, is exempt unless it's for child support or you owe the government money. 54, fill in the blanks. Okay. If direct deposit reasonably identifiable as statutorily exempt payments, so like Social Security, alimony, maintenance, were made to the debtor's account during the 45-day period preceding the date a restraining notice was served on the banking institution by a marshal or sheriff, $2,500 is exempt from an application to the satisfaction of a money judgment. So 45-day period, $2,500. 55, in general. Now, I don't know if they're going to ask this, but it's in my other video that I'm going to find. So basically, this is how I remember it. It's Rockland, Westchester, and Putnam counties plus downstate. So New York City, Long Island, Rockland, Westchester, Putnam. It's the highest amount because that's the most expensive places to live, and it's $150,000. For Dutchess, Albany, Columbia, Saratoga, and Ulster, it's $125,000, and for the rest of the state, it's $75,000. So the capital region is $125,000, downstate is $150,000, and everybody else, it's $75,000. Number 56, beginning April 11th of 2012, and at each 3-year interval ending on April 1st, thereafter, the dollar amount shall be adjusted. So this is for the cost of living adjustment as reflected in the self-support reserve thing. 57, besides a wedding ring, so every other art, watch, jewelry combined together, not exceeding $1,000 in value, are exempt from judgment. So if something is more than $1,000, then it's not exempt. Tools of trade, professional instruments, furniture, and a library not exceeding $3,000 are exempt from a money judgment. 59, this is true. This is the same thing as in question 1, a post-trial motion. And this is saying that in addition to motions made orally immediately after decision, verdict, or discharge of the jury, there shall be only one motion with respect to a decision by a court or a verdict. So you're only allowed to make one motion. If you stand up in court and yell, I move to vacate the jury's verdict, my client should have had $5 million and this stupid ass jury only gave him $100,000, then that's it. You cannot go and write a motion even if you do it within the 15 days. You get one shot at that motion. That's what this is saying. 60. Tough question. Not sure it will be on a one test, but who the hell knows, it's OCA. Which are true concerning a receiver appointed by a court to administer, collect, improve, lease, repair, or sell any real or personal property in which judgment debtor has an interest. Just in case somebody doesn't know what this is talking about, this is, in Article 52, is enforcement of money judgments. So let's say I have a money judgment against someone. I am the judgment creditor because I already got the judgment against them. I know that this guy I have a money judgment against, he owns a house somewhere in Long Island. And he knows I'm probably going to commence a special proceeding to force him to sell that house to satisfy my money judgment. So he's like, you know what? Fuck this place. I'm just going to let it go into complete disrepair. I'm going to let everything rot. The roof is going to be, falling in, and I don't care. The court is protecting my interests in that property by appointing a receiver to repair, lease, improve, sell this property. And it can be done with personal property too. Could be that, he owns a car and he's going to let it, rust and get 1 million tickets on it so that I can't use it to satisfy my money judgment. Everything here is true except for 4. And I'm going to correct 4 when I read it. 1. As far as practicable, court shall require that notice be given to the judgment debtor and to any other creditors of the judgment order. So, if I'm going to get a receiver appointed, I want the court to appoint a receiver, but this guy's got like 3 other people he owes money to, I got to notify the creditors, those other creditors, and the judgment debtor, and the guy. 2, the order of appointment shall specify the property to be received, the duties of the receiver, and the manner in which they are to be performed. It's got to be specific. It's got to say, Mr. Macaluso, you are ordered to go to Nassau County, find this house, sell it, list it, do this. Specify specifically. 3, a receiver shall have no power to employ counsel unless expressly authorized by the court. Okay? And 4, unless I, as the creditor, is appointed receiver, all receivers shall be entitled to necessary expenses and such commissions not exceeding 5% of the sums received and dispersed. Okay, so what does this mean? It means that if I'm going to be appointed receiver to sell this guy's house or sell this guy's car, then I don't get 5% commissions. But anyone other than the judgment creditor who is appointed receiver is going to get the commissions. So that's why number 4 was wrong, and the answer was D, all but 4. 61, in general, an execution shall be returned to the clerk of the court from which it was issued on the support collection unit within 60 days. But maybe you're taking the test, you'll hear something about a support collection unit, execution returned to the clerk, and you'll be like, oh shit, I remember that crazy bitch yelling it was 60 days. So hopefully that'll work. 62, a court may designate either, 1 if it's a JHO, or 1 or 3 referees. So if the referee is a JHO, he's like kind of special, so he's only 1. But if it's just some regular court attorney referees, the court can designate 3 of them. But the point here is, no, that they can't designate 2. We don't want a tie. We want 2 against 1, or we want just the 1 JHO. So the answer there was 3 and 4 only, so the answer was D. Okay. So what I decided I'm going to do with those group of questions in Article 43 is I'm going to review the entire article. That article was not on any test that I ever took, I don't think. So I don't know if maybe they've pulled some old questions on it, but either way I want to spend some time on it, so I'm going to do an old-fashioned, really statute video where I go through the statute. Look it up. So I'm going to skip to number 70. Number 70, a judgment order shall not be stayed, impaired, or affected by any mistake, defect, or irregularity in the papers or procedure in an action not affecting a substantial right of a party. A trial or an appellate court may require the mistake, defect, or irregularity to be cured. So this goes back to the same thing that we were talking about in Article 30 and in Article 23. Substantial right of party not affected. What do we do with the mistake, irregularity, or defects? We ignore them. They're supposed to be ignored. Okay? We want merits over fluff. 71. Another 15-day rule. Within 15 days after receiving the transcript from the reporter or any other source, the appellant shall make any proposed amendments and serve them and a copy of the transcript on the respondent. And there is a crazy 4-day rule in 5525 sub C, which, oh God, I don't even remember it. All right, so let's go over my notes on the bottom here, that a judgment rule is the SPAJO, summons, pleadings, admissions, judgment, orders affecting final judgment. And then there's the record on appeal. So this is the judgment rule versus the record on appeal. What is the record on appeal? This question was on my one test in some way. The notice of appeal. 2, judgment roll. 3, corrected transcript or the 5527 statement, which is a statement in lieu of record on appeal. 4, any relevant exhibits or copies of them. 5, any reviewable order. And 6, any opinions on the case. Now, back in 2007, when I was learning this, I didn't know what an opinion on the case was. I thought it sounded absolutely ridiculous. Like, I have an opinion on a case doesn't fucking mean shit. But an opinion on a case in, like, the legal world means, like, someone important wrote an opinion on a case, and that could be submitted. That's part of the record on appeal. Okay?